Corporate Board Member Magazine, an NYSE Euronext company, presents special board committees for M&A transactions with George Casey and Eliza Swann, partners in the law firm of Shearman Sterling.
Welcome, George and Eliza. Our topic today is going to be talk about special committees during an M&A transaction. And while we haven't seen a lot of M&A in the last 2 years, we're starting to see a little bit of a pickup. We're seeing both strategic and financial buyers looking at some possibly undervalued companies and looking at opportunities to build their own brand. So with that comes scrutiny, and scrutiny means that the board has to be sensitive, and so that brings up the issues of special committees. So George, why don't we start with you? Talk a little bit about the circumstances in an M&A transaction where a board wants to make sure that they form a special committee.
Yes, TK, and you're right. We are seeing an increase in M&A activity, and in fact, in recent transactions, we've seen a number of circumstances where special committees were created. Generally, as a board member, you may not often see special committee on your board. You may not have heard of a special committee created on your board to consider an M&A transaction as opposed to maybe some other circumstances. Special committees are set up in extraordinary circumstances. Typically when there is an insider, a shareholder, a member of the management, another director on the other side of the table. Those are the circumstances that, as a director, if you hear that a transaction like this is being considered, you may want to ask a question: do we need to have a special committee? The answer would not necessarily going to be yes, but it's important to think about it and think whether, in fact, you need it, because it's going to be a question of how the board ran the process. When the transaction becomes public, it's going to be scrutinized, and the shareholders, the media will ask the question: how did you, the board, get comfortable that this transaction is fair to the shareholders, not a special deal to the insider? And it's really that process that people are going to be paying attention to. If there is any suggestion that there is a conflict of interest, it's very likely that the shareholders will challenge that type of a transaction in a court. And so when you appear and this transaction is reviewed by the court, in fact, is going to look at a transaction where there is a suggestion of a conflict of interest under a microscope, and will try to determine how was the process run, how did the board run this process. What the special committee is designed to do is to replicate the arm's length negotiations between the company and the board on the one hand, and the insider on the other hand, as the board and the company would be negotiating with a third party. And so it's that process that's paramount. It's that process that people are going to be paying attention to. And if that process is run properly, if the special committee is empowered well and the special committee does its job, it's going to be good for the company, and it's going to be good for the party proposing the transaction.
Eliza, let's talk about the powers that need to be delegated to this special committee, because they're going to be sitting out there, sort of as an independent committee of the board. Let's talk about actually what powers get delegated to that committee.
Well, TK, I think that there are two crucial powers that a special committee needs to have in order to perform its job effectively. The first of those powers is the power to hire advisors. These typically include independent financial advisors and independent legal advisors. But they could also include other types of advisors, for instance, consultants or other advisors that the special committee feels are necessary in the particular circumstances of that transaction. And the reason why this is so important is that, as George discussed, process is paramount in special committee deals, and deals where special committees are necessary. So a special committee is going to want the advice and the guidance of its advisors in constructing and in executing a process that does its job in protecting both the committee as well as the transaction and the other parties who are involved in the transaction. The second crucial power for a special committee to have is the exclusive authority to negotiate the transaction that's on the table. A special committee's role, its fundamental role, is to serve as the independent arm's length negotiator in connection with the deal. This is a role that cannot be shared by management or any other interested party with respect to the transaction. It needs to be vested exclusively in the special committee. So this is something that is obviously crucial for a special committee to have. In addition to that, a special committee may also want the ability to consider and to negotiate alternatives to that deal that is on the table. Now, this may not make a lot of sense in a circumstance where you have a controlling shareholder who wants to do one deal and one deal only and is not ever going to approve an alternative to that deal. However, that doesn't mean that it still is essential for the special committee to have the ability to exclusively negotiate the deal. In some circumstances, it may also make a lot of sense for the special committee to have the authority to negotiate and consider alternatives to that deal.
Eliza, you bring up an interesting point, though. Here you have management doing their thing related to the deal. You have this independent committee trying to do their thing, yet they still have to function. They're within the same company. So talk a little bit about how they do function during that process where you have a special independent committee.
Right. Well, I think one of the first things that the special committee is going to want to do is actually have an interaction with management and ask them one very important question, and that is, what happened? What happened up until this point, so that the special committee can get a very thorough sense of the background that led to the process that they are now being asked to oversee. In that light, there may be a lot of questions that go to the special committee's understanding of what has come before in this process, and they could be questions with respect to what conversations have taken place and among which parties. With respect to any interested parties in the transaction, have there been conversations by those parties with respect to those interests? So, taking management as an example, has management had any conversations with respect to its compensation or its own equity rollover arrangements? Has there been information that has been passed over? Has there been confidential information of the companies that has gone out to third parties? These are all the types of questions that a special committee is going to want to sit down and ask of management and have management answer thoroughly in order to understand the background to the process. A special committee member cannot put him or herself in the position of having been blindsided and not having understood a fact that someone else could come in later and say that they should have known at the outset of the process.
And it's also important to keep in mind that going forward, right, in addition to the history that Eliza mentioned, going forward, the special committee needs to establish who is in the driver's seat. This goes to the power to really negotiate exclusively, as Eliza pointed out. And that's where the special committee needs to say that we are in the driver's seat, we are running this process, we have to be the exclusive negotiator, because if this transaction is scrutinized, people are going to be paying attention to the process, and it's that process that's going to protect the how the directors perform their duties, but also will protect the transaction that's, if it's a good transaction that's on the table. It's also important to keep in mind that when the transaction gets announced, it's going to be described in excruciating detail in the proxy statement, in the tender offer document, and ultimately will make its way into the media. And people are going to be reading about what the special committee did in a day-by-day manner. They will know whether the management had separate contacts or whether the special committee ran the process. And it's that type of a process, that type of information that people are going to be paying attention to. And at the end of the day, the crucial question as to whether or not this process was run properly would be, did the independent directors, did the special committee, if it was created, do the right job for the shareholders? Were the interests of the shareholders protected? If the answer to that question is yes, then the special committee, the independent directors, even if special committee was not created, if the answer is in the affirmative, then it means they've done their job right.
Well, we do know in today's governance environment that the boards are being asked to be very transparent. And the fact that the light gets that much brighter during an M&A transaction really means that you have to do what's right.
Absolutely.
So great advice for any of our viewers. Again, they're going to find themselves either on the buying or the selling side of this and need to be knowledgeable about it. So thanks for joining us today.
Thank you, Jimmy.
George Casey can be reached at gcasey@shearman.com. Eliza Swann at eliza.swann@shearman.com. This has been a presentation of Corporate Board Member Magazine, an NYSE Euronext company.